Fletcher Tabuteau.
For the opportunity, sir. I thought I'd start this evening in terms of a contribution around the title and the commencement date, because I'd like to acknowledge an earlier contribution from my colleague on this side of the House. And I speak first to the commencement date and make reference, well, I won't go through the specific Speaker's ruling, but it does say if the commencement date is amended, which it has been in this legislation, then actually the vagueness of the start date is not only inappropriate, but it's not acceptable under the House's rules, sir. So, and I note that it was changed when it was brought to the House in this version, so that we could make some vague statement around the date on which the Trans-Pacific Partnership Agreement done at Auckland on the 4th of Feb enters into force. It's not specific enough according to the Speaker's ruling 132, and I think the consideration asked for by the member earlier is not only valid but needs serious consideration for the House to come back and hear the Speaker's ruling on that. I thought then to speak to the title, sir, and what I thought was what we've got currently is a Trans-Pacific Partnership Agreement Amendment Bill, but I thought the Trans-Pacific Partnership Agree Anything Amendment Bill might be more appropriate. And I say that because I've never had the privilege of speaking to Mr. Grosset, and I do feel I do feel like I have missed out on a wonderful opportunity. But what I have had the opportunity to do is speak to previous employees of MFAT. And the conversation ran around the fact that the previous minister's stance on trade agreements was let's sign up to anything and then come back home and sell it to the people as something that's great for this nation. And I think the TPP is perhaps the prime example of an agreement being brought back to New Zealanders as a gold standard, and it could only be a gold standard if it was agreed to by the minister. And I think New Zealanders will find that it is absolutely not that at all. And I wanted to speak, and I quote a word really from one of the submitters, and they were flabbergasted by the analyses and numbers used in the interest analysis, which they used to inform their submission to the Select Committee. And I make that reference, sir, because in our analyses of this partnership agreement, the Select Committee was essentially forced to use an analysis that was abbreviated, it was a shorthand, and to be quite honest, it was insulting at times in the numbers that were given to us and what we were expected to take at face value, especially when we were able to contrast it with overseas analysis done, and actually, to be fair, some contributions from academics here in New Zealand. So the point there, sir, is we're talking about an amendment legislation to the Trans-Pacific Partnership, which in the main, I have to say, is quite technical and quite small, because we're a country that's already set up to go in the main. But that word flabbergasted by analysis and numbers used was a direct quote from one of the submitters. And this is what we're having to go through now when we look at submissions, when we look at the enabling legislation in front of us. We weren't given the information that we required to truly understand what the implications of this, what the enabling legislation would bring about, such that, for example, the copyright terms, the patent procedures, for example, the Honourable Annette King, sorry. What a Freudian slip, sorry.
The other Annette.
That was not intended as... Yeah. So she spoke about the Pharmac transparency model, and I would have to agree with her completely. So the situation with that model, which is part of the enabling legislation, is such that we have requirements on Pharmac to now produce reports that can be used by any interested... Mr Chair?
Fletcher Tabuto.
Thank you, sir. That can be used by any interested party in an analysis of Pharmac's decision-making procedures. And the conversation around that, sir, was an uncomfortable state in that we know, and I use that word strongly, I admit, we know that a lot of those overseas international corporates will be using that facility to attack Pharmac's decision-making on behalf of the people of New Zealand. Now, I've had some debate online with some pretty reputable people who know a lot about the Pharmac model, and they tried very vehemently to dissuade me of my thinking, but this is the truth of the situation. There is that whole question mark around transparency, and what I want the House to realise is, actually without even going into a renegotiation round, because we don't know what the Clinton or Trump blocs will do in terms of the ratification process, is right now it's our understanding that there are side letters being circulated around the member countries trying to circumvent what is a locked-in agreement, such that we will be obliged to extend those patent extension periods even further. So these side letters are being circulated, that's what we are being told, but in an agreement where the American administration, by way of their process, have locked it in. And we have said we will not renegotiate. And yet these side letters are being circulated on Pharmac, and so it's a huge question mark, sir, as to what will happen with our biologics, and we know how critical they are as we move into the future. So the issues are technical, as I said. They are minor, a lot of them, but there are a few significant changes where many of the submitters, especially around copyright and access to technology, I'll find the technical term for a later submission, were almost at odds in their contributions to the House. It was a confusing piece of legislation for both sides of the argument. And even those who supported it would often tell the Select Committee that there was a great deal of confusion, a lot of unnecessary detail in terms of the law, and it made for a confusing read, and many of the submitters said, let's just not do it, let's wait for the ratification to go ahead so that we actually know what it is that we're signing up to. I just want to finish this contribution, sir, by saying that we are here today after having completed the second reading quite precipitously. We're here now going through the motions, and yet we have Japan who are going to run this through their lower house very quickly to beat us to the goalpost in terms of supporting Obama's attempt to push this through in the lame duck period, but actually that's fallen by the wayside. We've got Canada who's been prepared to stand up from the start and say, we're not going to say anything about this until we've had genuine engagement from the public of Canada. And they mean genuine. They're still going. A year later, they are still engaging with their community base. We've got Vietnam, who had a great level of support from their public, actually, from their people, but the government's decided actually they're not in a position, and they don't want to be in a position, to race through their ratification, and that sent quite a strong message to the Obama administration regards his efforts in the lame duck process. And I say to the House this evening that we don't need to be here, we shouldn't be here. Submitters themselves have talked about the confused nature of what it is they're submitting to because of the interest analysis. And so much of what we see here is confused, it's unnecessary, and as I said at the start, sir, the timing of it is entirely in question. Thank you very much.
Mr Chair. The Honourable